Imagine you are the most powerful person in the United States. You are the president. You have the bully pulpit, the Secret Service, Air Force One, and the full force of the executive branch behind you. And a federal judge, a single judge sitting in a courthouse in Rhode Island, just looked your administration dead in the eye and said, "There is no excuse for not complying with my order." Not a suggestion, not a polite nudge, a flat-out rebuke from the bench. And here is the kicker. Your administration still hadn't moved. That is exactly what happened on June 11th, 2026. And folks, this is not an isolated moment. This is the latest chapter in what is becoming one of the most extraordinary legal collapses in modern American presidential history. We're going to break all of this down for you today. The full picture, what the judge said, what the administration did and did not do, why the courts keep smacking this White House down over and over again, and what all of this means for you, for this country, and for the future of executive power in America. Before we get into it, if you are new here, welcome. Hit that subscribe button right now. This channel brings you the real story behind the headlines, without the spin, without the fluff. If you already watch us regularly, drop a like on this video. It genuinely helps more people find this content. And if you know someone who needs to hear this, a friend, a family member, someone you argue with at Thanksgiving, share this video with them. Okay, let's get into it. Let's start at the very beginning of this particular showdown, because context is everything here. Last year, 2025, 2 National Guard soldiers were shot and killed near the southern border. It was a horrific tragedy. The Trump administration used that shooting as the trigger to implement a sweeping policy freeze on immigration processing. U.S. Citizenship and Immigration Services, the agency everyone calls USCIS, suspended the adjudication of all asylum applications. Not just for people who crossed illegally, not just for people with criminal records, for everyone from a list of 39 countries spanning Africa, the Middle East, Asia, and Latin America. Countries like Iran, Nigeria, Venezuela, Afghanistan, 39 nations in total. Now think about what that actually means in practice. There are hundreds of thousands of people living in this country right now who were doing everything right. They applied through legal channels. They waited years for their cases to move forward. They were paying taxes, going to work, raising kids. And overnight, because of where they were born, a complete freeze was slapped on their cases. No hearing, no review, no end date, just frozen, indefinitely. As one federal judge put it later, these people were thrown into what he called indeterminate legal limbo. Can't work legally, can't plan for the future, can't bring family members over, just stuck with zero explanation other than where they happened to be born. And here is what the administration told the courts to justify this. National security. They said the national security threat posed by nationals of these 39 countries was reason enough to blanket pause every single application, no matter how long the person had been here, no matter their individual circumstances, no matter what the law actually said. Now enter Chief U.S. District Judge John McConnell. He sits in the District of Rhode Island, and on Friday, June 5, 2026, he issued a 135-page opinion, 135 pages, dismantling the Trump administration's legal justifications piece by piece. And Judge McConnell did not mince words. He wrote that USCIS claims statutory and regulatory authority that it does not possess. He wrote that the agency makes decisions without the reasoned explanations that it must provide. He wrote that USCIS acts without regard for the reliance interests of applicants that it must consider. And most damning of all, he wrote that the agency justifies its actions with pretextual concerns of national security that mask anti-immigrant sentiments that it is forbidden from letting influence its decision-making. He concluded, quote, "In legal terms, that means USCIS's actions are contrary to law and arbitrary and capricious." That is a federal judge appointed by the United States government reading the law and saying, this isn't national security policy. This is discrimination dressed up as policy. And it is illegal. His order was clear. Restart the processing. Lift the freeze. Comply immediately. So what did the Trump administration do? Nothing. For days, nothing. 6 days later, on June 11th, Judge McConnell called them back into court. And that is when he delivered the line that has now gone viral in legal circles. He told Trump officials there was no excuse for not complying with his order. A federal judge in the United States of America telling the executive branch of the United States government, you have no excuse. Follow the law. Now here is where this story gets even bigger, because what happened with Judge McConnell is not a one-off. What we are seeing right now is a systematic, widespread, almost unprecedented pattern of the judicial branch, judges appointed by Democrats and Republicans alike, repeatedly and forcefully ruling against the Trump administration, often on the same core grounds, that the White House is acting outside its legal authority. Let's talk numbers, because the numbers here are genuinely staggering. According to reporting by Politico, the Trump administration's track record in court on immigration alone stands at roughly 10,400 losses compared to about 1,200 victories. You heard that right. 10,400 court losses. In the area of IC detention practices specifically, federal judges have rejected the administration's actions in approximately 90% of cases since the administration expanded its mandatory detention policies. 90%. That is not a close legal argument being decided on the margins. That is a systematic failure to operate within the law. And the courts are not just ruling against the administration. The tone coming from the bench has escalated dramatically. Politico reported earlier this year that judges across the country are growing, and I am quoting here, increasingly furious and exhausted as the administration continues to openly defy court orders on mass immigration enforcement. Courts are now proactively threatening to hold Trump administration officials in contempt. Contempt of court. That means potential fines, potential jail time for government officials who refuse to follow judicial orders. We are in genuinely uncharted territory here. Let me give you a few more examples, because the pattern becomes unmistakable when you line them all up. Take the case of Christian, a Venezuelan asylum seeker who was wrongly deported to El Salvador's notorious Seco prison. The judge in that case, District Judge Stephanie Gallagher. And here is the part that should make your jaw drop. Gallagher was appointed by Trump himself during his first term. She is not some liberal activist judge. She is a Trump appointee. And she absolutely tore into the administration. She wrote that the government had utterly disregarded her court order. She noted that when ordered to provide a status report about the wrongly deported man, government attorneys essentially told the court they haven't done anything and don't intend to. She wrote that administration officials not only ignore the requirements of this court's orders, but also make no attempt to offer any justification for their blatant lack of effort to comply. Her final verdict on the government's response, it reflects zero effort. Zero. Then you have Judge Randolph Moss, an Obama appointee, who blocked Trump's executive order barring migrants who crossed the border illegally from even applying for asylum. Judge Moss wrote that neither the Constitution nor federal immigration law gives the president the authority to replace the comprehensive rules and procedures set forth in the Immigration and Nationality Act with an extra-statutory, extra-regulatory regime. In plain English, Congress wrote the immigration laws. The president cannot just unilaterally rewrite them because he wants to. And then there is the birthright citizenship fight, which is still working its way through the courts. Multiple judges have blocked Trump's executive order on birthright citizenship, all of them pointing to the same thing: the 14th Amendment to the Constitution. The plain text: the law of the land since 1868. Judges from different states, appointed by presidents of both parties, have said the same thing. This executive order violates the clear language of the Constitution. Trump took that fight to the Supreme Court, where even his own conservative majority court gave the administration a cool reception. Now, let's be real with each other here, because this is a debate channel and we give you both sides. The Trump administration and its supporters have a response to all of this, and it is not nothing. Their argument goes like this: the courts are overstepping. Single district judges appointed by political opponents are blocking national policy decisions that affect hundreds of millions of Americans. DHS General Counsel James Percival put it bluntly when he said, and I'm paraphrasing because these are fighting words, that the left has been running what he called a gambit with so-called discrimination claims since 2017. He called it sabotage dressed in legal clothing. The argument from the administration's corner is essentially, we are trying to keep Americans safe. We have legitimate national security concerns, and activist judges are tying our hands. And look, there is a real policy debate here that reasonable people disagree on. Illegal border crossings did drop dramatically under Trump. Border Patrol encounters in June 2025 fell 93.1% compared to the same month the prior year. Tom Homan, Trump's border czar, called it the Trump effect. Those are real numbers. Border security is a real issue. The question of how to handle asylum claims from countries with limited information sharing with the U.S. government is legitimately complicated. But here is the problem with the administration's legal argument, and the courts keep identifying it over and over again. There is a difference between having a policy goal and having the legal authority to pursue it. The courts are not saying immigration doesn't matter. They are not saying national security doesn't matter. What judge after judge after judge is saying, Republican-appointed and Democrat-appointed alike, is that the way this administration is pursuing those goals violates the law. You can't just freeze hundreds of thousands of legal immigration applications with no legal basis. You can't use war powers to deport people who have never been charged with a crime. You can't issue an executive order that flatly contradicts the text of the 14th Amendment and expect the courts to just go along with it. The separation of powers is not a technicality. It is the architecture of American democracy. And what we are watching right now is that architecture doing exactly what the founders designed it to do, the judicial branch checking executive power when the executive branch overreaches. And the overreach has been breathtaking in scope. Let's zoom out for a second and look at the full legal battlefield. Courts have pushed back on Trump's use of the Alien Enemies Act to deport alleged Venezuelan gang members, with one judge writing that this approach represents a path to perfect lawlessness. Courts blocked the detention of students with anti-Israel views, with one judge invoking the Red Scare and McCarthyism. Courts have repeatedly blocked birthright citizenship rollbacks. Courts have blocked asylum bans at the border. Courts have ordered the administration to provide due process to deportees. The Supreme Court itself has issued 3 separate reminders to the Trump White House about its obligation to provide reasonable due process to people it has accused of being alien enemies. And through all of this, there has been a consistent response from the administration: delay, defy, appeal, and attack the judges personally. Trump went on Truth Social and wrote, and this is a real quote from a sitting American president, "Dumb judges and justices will not a great country make." He has repeatedly attacked judges by name, by party affiliation, by who appointed them. His allies in Congress have floated the idea of impeaching judges who rule against the administration. His supporters on social media have gone after federal judges' personal safety. This is where the debate gets genuinely alarming for a lot of constitutional scholars and former officials across the political spectrum. Because there is a meaningful difference between disagreeing with a court ruling and refusing to comply with it. There is a meaningful difference between appealing a decision through proper legal channels and publicly attacking the legitimacy of the judiciary. When the executive branch of the United States government starts treating court orders as optional, you are no longer in a policy disagreement. You are in a constitutional crisis. And the people who know this best are the judges themselves. These are not political operatives. These are lawyers who spent decades studying the law, who were vetted, confirmed, and put on the bench to interpret it. When Judge McConnell sits in his courtroom in Rhode Island and tells the most powerful government in the world that there is no excuse for noncompliance, he is not doing that because he has a political agenda. He is doing it because the rule of law, the actual rule of law, not the slogan, but the real thing, requires that court orders be followed by everyone, including the President of the United States. Here is what makes this moment historically significant. We are watching in real time a test of whether the rule of law in America is real or not. The founders designed the system with 3 branches of government precisely because they understood that power concentrated in any single person or institution inevitably leads to tyranny. The judiciary is the backstop. It's the last line of defense. And right now, that backstop is being pushed harder than it has been in generations. The courts are holding, for now. But there is a legitimate question that historians and legal scholars are starting to ask, and it is a serious one. What happens if an administration simply refuses to comply? Not delays, not appeals, just refuses. The judiciary has no army. It has no enforcement mechanism beyond the moral authority of the law and the willingness of the other branches to respect it. If that respect breaks down entirely, we are in unprecedented territory as a nation. Now, some of you watching this are Trump supporters. Some of you are not. But I want to ask you something regardless of where you stand politically. Ask yourself this question. Do you want the president, any president, to have the power to ignore court orders? Because the precedent being set right now does not belong to one party. If this White House establishes that executive branch defiance of the judiciary is acceptable, that power does not disappear when the next administration takes office. It gets inherited by whoever comes next, whatever party they represent, whatever agenda they have. The tools of unchecked power do not stay in the hands of the person who built them. That is why this story matters far beyond immigration. Far beyond asylum, far beyond any single court case. What is being decided right now in courthouses across this country, including that courthouse in Rhode Island, where one judge just said there is no excuse, is whether the rule of law in America is a living reality or just a phrase on a plaque. 10,400 court losses. A 135-page opinion calling the administration's actions illegal and arbitrary. A Trump-appointed judge saying the White House showed zero effort to comply. Judges appointed by both parties growing furious and exhausted. And a federal judge, on June 11, 2026, looking at the executive branch and saying out loud, "You have no excuse." The losses are piling up. And the question every American needs to be asking right now is not whether you agree with the immigration policy. The question is, what happens to a country when its government decides the law is optional? We will be watching this story closely, because this is not over. Not by a long shot. If this video gave you something to think about, something real, something substantive, please hit that like button. It takes 2 seconds, and it genuinely makes a difference in how many people see this content. Subscribe to this channel if you're not already here. We cover the stories that actually matter with the depth they deserve. And share this video. Send it to someone who needs to hear this. Drop it in a group chat. Post it to your social media. The more people who understand what is actually happening in these courtrooms, the better informed we all are as citizens. Thank you for watching. We will see you in the next one.